Hello, good evening, students. Good evening, all of you, and I hope you all are preparing yourself for your exams. So today is the last class for the law of tort, and today we are going to learn about defenses and remedies in tort. Just without wasting much time, because time is a factor, I have directly started the slides. But just to set the perspective, I want to remind you that uh, if you remember, we have already learned defenses when we were learning, the chapter on negligence, where I said there are different defenses. I also sent you some points on general defenses under the law of tort. We are going to just reiterate certain things in our class today, but I thought let me go through all of it again so that it would be a kind of revision also for you, as well as like we are just touching upon the last chapter as well. Now, regarding torts, tort is a civil wrong. Now, what are the defenses for the person who is accused of committing a tort, or in the law of tort, he's called as the tortfeasor. So what kind of defense would he cling to, or what kind of defense would his lawyer plead in the court? So we are going to learn about that. Apart from that, we are going to learn about remedies. Now, what are the remedies available for the aggrieved party? That is the person who is hurt by the tortfeasor. Now that person becomes the plaintiff in a case. So what are the remedies for him? So one of the remedies we said is the obvious one, that is damages. And mostly it is in the form of compensatory damages, also general damages. We said there are different kind of damages. We said there is nominal damages, liquidated damages. When we learned about negligence, we spoke about damages, and we said that there are different types of damages that the court may award in case of the wrong of tort, or when tort is committed, and the damages may be awarded for the damage. Just note the way I'm using the words here. Damages may be awarded for the damage. So there is difference between, just to remind you what we learned last time, there is difference between damages and the word damage. Damage is to cause harm, and damages is in terms of compensation. We are referring to compensation. So damages are basically the prime remedy in tort actions. Mostly, and most of the times, people claim damages, that is compensatory damages. That is the prime remedy that is sought in the courts of law today. Say, for example, there is a defamation case where someone's, reputation is tarnished. That is one of the torts, defamation. And I remember I told you defamation can be a criminal offense depending upon the jurisdiction and the country. Like, for example, in India, it's a criminal offense as well as it is a civil wrong. So a party can bring a criminal case as well as a civil case simultaneously. But whereas in some countries, they say you have a choice. You either file a civil case or you file a criminal case. And in some countries, they say that no, it is just a civil wrong. It need not be necessarily a criminal wrong. For example, in Australia, there are some states in Australia which regard defamation as a criminal offense. And there are some states which say that no, it's okay, it's just a tort. Now, when it is a tort, the question of remedy comes when it is a tort. When it's a criminal offense, of course, there is again, pecuniary damages, that is in terms of money, punitive damages, in terms of punishment in the form of fines or compensation that may be awarded. Apart from that, there is imprisonment as well in case of criminal laws. But in case of tort, the basic remedy is normally in the form of compensation. So damages are said to be the prime remedy in tort actions. Now, most likely sometimes there can be nominal damages, that is nominal damages, and that is very rare. And if if you say that compensation is a dominant action or a dominant purpose of tort actions, that means what about the vindicative part of it? Sometimes the purpose of awarding damages is not just the compensation part, but also vindication. Now, what do I mean by using the term vindication? It means that it's always, in simple terms to put it, it's not always related to money, that is receiving compensation for the harm that is caused. For example, you say invasion of privacy. Okay, invasion of privacy. Now, there is no real harm to property done. Okay, this just invasion of privacy, say it's a tort. Now, once privacy is invaded, now that is irreversible. So when it is irreversible, it cannot be changed. So how would you compensate for that for that person? The person says, no, my privacy is invaded. So how would you compensate? No, like some personal life of the person is exposed to somebody. So how would you compensate? So will money, if if you ask a particular amount of money, still the person may not be satisfied. So sometimes they award, depending upon the reputation of the person, depending upon the facts and circumstances of the case, the court may ask for, ask the defendant to pay a huge sum of money in the form of vindication. So the purpose sometimes is not always to commensurate, that is to match with the nature of the privacy tort, but also to consider the factor whether the harm that is caused is reversible or irreversible. Now, this is something that occurs to our mind always. Also about the reversibility factor, that money can always not sort out all issues, but sometimes in law, you can claim compensation in the form of damages or money, also in as a form of vindicating, in the form of, as a form of vindication. So it may not, the amount may not undo personal or psychological injury or psychiatric injury, but however it can compensate maybe some kind of, somewhere where the person might require something financially, and it might provide some sort of solace or peace for the wrong that has actually been caused, or whether for the wrong that has been committed against the person. So the vindicatory effect of damages, of awarding damages, also has to be considered. Next is whether the tort is actionable per se or not. Now listen to me carefully, because all of this is not in the slides, so I'm just talking as it is coming. So I told you one thing is, apart from compensation, the purpose of giving remedy or providing damages in tort is also vindication. Okay. Now, apart from that, I'm talking about torts which are actionable per se, that is on the face of it, that is which does not require any further proof. It's actionable per se. Like for example, assault. Somebody assaults another person, A assaults B, or in the form of battery, a form of assault. So, or trespass to a land, or even defamation for that purpose. It's actionable per se on the face of it. Okay. And there are torts which may not be actionable per se, and it has to be proved. That is, the extent of damage has to be proved, and then the court may award unliquidated damages. That is, it is up to the court for calculating the damages that is caused. Next is damages for emotional or mental distress that is not always considered by the courts, and it is not really written down in a lot of texts. But there is arguments among the legal fraternity saying that even for emotional distress that may be caused, or psychological stress, also a person can claim. And there are people who are contending at that level, and they're not always successful. It depends upon the courts, and it depends upon the judges, because normally they look for something that is tangible losses. But the question is always about damages which are intangible, that cannot be seen easily, that you cannot really touch or see it directly. So like injury to your feelings, or or injury to your emotions, or emotional distress. So this is some yet another aspect which is now building on in the courts worldwide, and they are considering even the psychological part of it, and damages even for emotional distress. So we spoke about damages for emotional distress. We spoke about thoughts that are actionable per se, and we also spoke about the purpose of damages need not just be compensatory, but also it can be vindicative. Now let's move on further with the slides. Now, broadly speaking, damages or remedies in the law of tort can be judicial remedies or extrajudicial remedies. Now, I've just put a kind of a caption here, or rather it's a maxim, it's a legal maxim, that to every right there is a remedy. That is a famous legal maxim whenever there is remedies that are claimed before the law. So they say that to every right, because there is an invasion of right or infringement of right. That means whenever there is an infringement of right or violation of right, always there has to be a remedy. Now, in the law of torts, broadly, if you classify, there are two types of remedies that are granted. Broad classification. One is judicial remedies, and two is extrajudicial remedies. Now, what is judicial remedies? As the name itself suggests, that means the person has to go and knock the doors of the court to receive his remedy, or to remedify the problem or the defect, or to redress his issue, or to solve the issue. He has to go and knock the doors of the court to seek the remedy. So that is judicial remedy. The other part of it is extrajudicial remedies. Now this is the interesting part. What is extrajudicial remedy? Now, extrajudicial remedies are remedies which are conferred by law upon a person automatically, and he can, exercise that particular right even without knocking the doors of the court. Like, for example, say that, there is one Mr. A and he owns a land. Oh, okay, you say that he owns a field. Mr. A owns a field. This is the most common example I give, and it's also there, I think, in subsequent part of the slides. Say A owns a field, and B owns some cattle. B's cattle just stray into A's fields and destroys his crops. So now A has got the right to block the cattle from going back to Mr. B, and hold back the cattle in his land or in his property, and tell B, see, you're the owner of the cattle, and so you will have to pay me for whatever damages that are caused, whatever damages caused in my field. So you will have to pay damages for the damage that is caused. You'll have to compensate, and you will have to pay me X amount, and until you pay me, I will not release the cattle. So that is the right to retain something with you, the right of retaining some, like, for example, yet another example I could give you, like, probably when you're studying contract, you will learn bailments. So bailment, like, for example, what is an example of bailment? Would be like you're giving your clothes to a tailor, to get your dress stitched to a tailor. So when you give to the tailor, and say you don't pay the tailor money, so the tailor, say now you stitch 2 dresses, and then after that you tell the tailor, okay, I will pay you the next week, and the other week, and the other week, and you don't pay, and then again there's a 3rd dress, and he's kind enough to stitch it for you, and then you still say no, it's almost 3 months or 4 months, and you still don't pay. Now the tailor is annoyed with you, and the tailor says, no, I will not release the 4th dress to you till you pay me the money, and the material is very expensive. His tailoring charge must be much lesser than all the 3 dresses, but the material must be expensive, and the tailor knows that. So the tailor will say, okay, I will not give you the dress back till you pay me the money. So that comes under bailment, that is contract. That's a different thing, but I'm just giving an example of extrajudicial remedies where a person has got the right to retain the property or something with the person that belongs to another until the other person discharges his duty or discharges his responsibility towards the person. So the law somehow gives that right to a person, and it comes within the purview of law. When it is a conferred right, then such a remedy is called extrajudicial remedies. That's what the slide says. When the aggrieved party has to knock the doors of the court and seek an effective remedy by following the due process of law, then such remedies are called judicial remedies. On the other hand, when the law confers certain rights to the aggrieved party, which will be exercised by the aggrieved party against the tortfeasor within the purview of law, that means it has to be within the presence of law, within the ambit of law. You have to act within the law. It has to be a right within the law. As a conferred right, then such a remedy is called extrajudicial remedies. Now, examples or the types of judicial remedies are, of course, damages in the form of compensation, monetary damages, and so on. Then, of course, there is injunction. You know what's injunction? I explained last time. It's like a cease and desist order. It is it's also called as a stay order in lay terms. A stay order or cease and desist order injunction, and this injunction may be permanent injunction, or it can be interim or interlocutory injunction, or there are different types of injunction. We need not go to the detail of it. I'll just touch upon this a little later, but just for you to know now, injunction, that is cease and desist or stay order. Try to recall what we learned during negligence. And next is specific restitution of property, that is to give the property back to the person. Now, about extrajudicial remedies, under that we have expulsion of the trespasser, that comes under specific performance, that is to remove the trespasser, the one who has trespassed your land, to remove the person out. Re-entry on the land, specific performance, that is if a person has dispossessed another person, to bring the person on the land or in the property or in the house. Then recapturing of goods, that comes again under specific performance. Abatement, that means either you ask someone to reduce the nuisance or remove the nuisance, abatement. Then there is distress damage feasant. That is the example that I gave you about cattle belonging to someone, where the person has got the right to hold back the property till the person compensates for the damaged crops. That comes under distress damage feasant. So these are extrajudicial remedies. And judicial remedies, where you can knock the doors of the court, is damages, injunction, specific restitution of property. What are the types of damages? You'll have different types of names. Even if you go to some other textbooks, you'll have different names. But practically and largely speaking, in a broader perspective, there is liquidated damages. Liquidated damages means certain damages. Certain damages are damages where the parties decide among themselves and say that if there is a harm that is committed, or in case there's a problem, then you pay me say around 50,000 dirhams or whatever is the currency, so and so amount. So that is certain damages when the parties ascertain the damage or agree for the compensation that needs to be paid in case there is a harm that is inflicted. Now, what is unliquidated damages? Unliquidated damages are damages which are ascertained by the courts, which are decided by the courts, which is calculated by the courts depending upon the facts and circumstances of each case, and depending upon palpable damages or tangible damages, what the court really assesses and thinks it is right in certain circumstances that can be awarded. So unliquidated damages are damages that are awarded by the court. Next is pecuniary damages. Pecuniary, the meaning of the word is something related to money. So pecuniary damages are damages that mostly aims at compensation in terms, monetary compensation or monetary damages. Next is punitive damages. Punitive, by the word punitive, means that immediately should come to your mind is something related to penalty. Something related to punishment. So punitive damages or penalty, it's also called as exemplary damages, which is in pecuniary terms, that is in money terms, such as fines. And it is imposed basically to deter future commission of tort, deter in the sense to lay a kind of an example to others and even to the person, saying that in case you commit this tort, you will such and such a fine you has to be paid by you. So the person normally says that if I have to do away with so much of money, I rather not commit this tort again. So that is to deter a person, that this may be in the form of punishment or to penalize the tortfeasor. Next is substantial damages. Substantial damages are awarded when the plaintiff is compensated for the exact loss suffered as a result of infliction of a particular tort. That means a court would see the exact loss that is suffered. It would calculate the exact loss, nothing more, nothing less. So, that is called as substantial damages. Next, we have nominal damages. These damages are awarded when the plaintiff's legal right is infringed, but there is no real tangible loss that has been caused or that can be calculated. In such case, the courts may charge the tortfeasor to pay nominal damages for the act of tort committed to the aggrieved party or plaintiff. For example, trespass of property. It's actionable per se, but something cannot be really calculated. Now, how much would you calculate for trespass? So the court would think, okay, nominal damages. Next is contemptuous damages or ignominious damages, which is awarded by the court, as a sign of, expressing its disapproval of some act of the plaintiff. So, the plaintiff also has not played it well, or he is not really in the right standing. The plaintiff also has committed some kind of a wrong, and he is not having a clear conscience or has not made a legitimate move while he was dealing with the tort before he filed the case. So the court basically, to express its disapproval, or in the sense that it does not like the act of the plaintiff, that is the aggrieved party, the one who is affected by the tort and the one who has filed the case, just to express its disapproval, to show that you also have not been in the right standing. So in such cases, an ignominious amount, that is a very humble or very low amount, may be awarded by the court to the plaintiff to be paid by the defendant, saying that, well, you were also not right, and it's not that he was responsible for the tort, but probably his actions were not legitimate before. It can be any action, they were not legitimate. So the court would say, well, you see, your actions also were not legitimate enough, so we'll just award some kind of, say a humble amount, a very small amount, or ignominious amount, or contemptuous amount. That is basically for the court does it when it wants to show its disapproval. Next is moral damages. Now, moral damages, sometimes it's normally in employment cases. Sometimes they claim such damages when there is oppressive behavior of the employer towards the employee. It may entitle an employee to moral damages. Now, the next thing is injunction. What is injunction? As I said earlier, cease and desist order from the court, or it's also called as a stay order in lay terms. Now, what injunction does is it prohibits the tortfeasor from continuing with the wrongful act. Example, like blocking third party's gate. Third party can bring an injunction order and further order to clear the path. So injunction is basically an equitable relief. Now, injunction may be a permanent injunction, that is like forever, or temporary, interim, or interlocutory injunction. That means while the case is going on, while the case is adjudicated, before the rights of the parties are proved, the court, the lawyer may file a petition, an interim petition for, interlocutory injunction. That means interim, that is in between. Interlocutory means in between, interim, in between a case. In between a case, sometimes they file, interlocutory application for, interim or interlocutory injunction. Next is mandatory injunction, that is where the law itself gives the right. It mandates for such an injunction. And next is prohibitory injunction. By the term, you understand something that prohibits. That means to prohibit a person, the court may, issue cease and desist order or an injunction order. Next is restitution. Now, when a person is unlawfully dispossessed of his or her property or goods, then he or she is entitled to restoration of that property. Example, returning stolen objects. That is to restitution means to return something that belongs to someone else. So the court may ask a person to restore the property back to the person from whom you have taken it. So restitution. Next is specific performance. Now, this you're going to study, probably if you're going to study the law of contract, and or I'm not sure whether you've already learned it. So specific performance, when the court feels justified that in there's a P missing here. In particular case, monetary damages wouldn't suffice in the pursuit of justice in the facts and circumstances of a particular case at hand. So the court may order for specific performance. Example, return the possession of property to a person who is wrongfully dispossessed. Example, the person is thrown out of the house. They'll say, no, the person does not have any other place to stay. Bring the person back into the house. Then we will decide about the rights of the person. Then yet another example could be that by asking a party under a contract, when there are contractual terms as a contract between parties, to perform his part of contractual obligation while the court decides about who's right, who's wrong. So that calls for specific performance. Next is remoteness of damages. This also we studied in the chapter of negligence. Remoteness of damages, or the way it is connected. So the damage inflicted should be directly related to the cause of the damage to be entitled to damages. That means the harm that is inflicted should be directly related to the cause of the damage to be entitled to compensation. So damages is the compensation that is adjudicated to be paid by the defendant to the plaintiff, and it will be awarded when it is proved that the act or the omission of the defendant has had direct relationship or direct nexus to the damage caused to the defendant. So here, the factor of causation, remember we discussed about the causation theory. This is the very same thing. The factor of causation, that is the relationship between the cause and effect, will have to be examined and tested here. So the relationship between the cause of damage and the effect of the damage itself must be direct and not remote. Thereby, it is not enough if there is a damage cause. The damage cause should be as a direct result of the wrongful act or omission of the defendant. Now, the relationship as direct or remote can be examined also through the lens of the factor of foreseeability. Remember, we spoke about foreseeability. That means whether the harm was foreseeable or was not foreseeable, whether damage was foreseeable or not foreseeable. Now remember, again, I'm reminding you, I'm using the word damage. There is difference between the word damage and damages. Damages is compensation. Damage is the harm that is inflicted. So whether now the harm or the damage was foreseeable or not foreseeable. In case we get disconnected, please join back. Next is, we already did this case, Smith versus Leash Bryan. If you remember that, the employee's, lip got burnt while he was pursuing some duties. And when he had a burnt lip, that, it triggered the precancerous cells and it was activated. And as a result, Smith died from cancer 3 years later. And then his widow sued this company, or the person, the employer, Leash Bryan. And the court said that damages can be awarded although the malady, that is the sickness, was unforeseeable. It was sufficient that the injury or the burn was reasonably foreseeable. So Justice Parker said here that the test is not whether these employers could reasonably have foreseen that a burn would cause cancer and that the victim would die. The question is whether these employers could reasonably foresee the type of injury he suffered, namely the burn, whether it was possible that they could foresee that a person can get burnt. So what in the particular case is the amount of damage which he suffers as a result of that burn depends upon the characteristics and the constitution of the victim. That means it depends upon the person's body, the person's physical, strength, or the medical state of a person. So it's not the question of cancer, but it's a question of that he has faced that burn and he has suffered that burnt lip. So that is a question whether the employer could foresee that burn could take place or not. Now, there are 4 factors that need to be connected, or questions that need to be asked when you solve a case of, generally a tort and also a tort of negligence. One is, does the defendant owe a duty of care? That is reasonability. Now, if it is in the affirmative, that is, if it is yes, then has there been a breach of that duty on the part of the defendant? That is foreseeability of the risk. Next, has the damage been caused to the plaintiff? That means whether there has been real damages that is caused. What is the nexus or the relationship between the foreseeability factor and the proximity of the damage that has been caused? And next is, are there any defenses that are available to the defendant? So these are the questions that has to pop up in the mind of a person to to solve the case and to arrive at a plausible conclusion or a formidable conclusion. Next is the defenses under tort. Now, what are the defenses for the defendant? So how can he defend himself saying that he is not really responsible? Some of it we have already done when we were learning negligence. So, of course, the first one is contributory negligence, which we already did. Next is voluntary assumption of risk, voluntary non-fit injuria. Next is vicarious liability. This also we did, but we'll repeat it again. Apart from that, which we have not done earlier, is because these are general defenses under the law of tort, and we did the 3 defenses under negligence. So 4 to 7 we'll go in detail today. Inevitable accident. Inevitable accident, there are, you can bifurcate it as act of God and human intervention. We'll do it later. Next is necessity, private defense, and plaintiff as a wrongdoer. We'll see what are these. We'll go through contributory negligence as well. Now, there is a partial defense where the defendant claims that the plaintiff, claimant, or petitioner acted in a way to contribute to the injury sustained or lost damage. That means he also has a part in that damage that is caused. So now the courts would basically here evaluate or assess the damages, taking into consideration the role played by the plaintiff that caused the damage, as well as the role played by the defendant that has caused the damage, and accordingly attribute it and appropriate the damages in such a way that justice is served, and would deduct plaintiff's, the role that he plays, which has caused the damage. They would assess it in their wisdom, and they would deduct, say, minus that amount and pay the balance, ask the defendant to pay the balance to the plaintiff. So that is contributory negligence. So it is basically concerned where there is plaintiff's failure also to take precaution, and the burden or the onus lies on the defendant to prove this. We did this already, so I'm just rushing through. Next is voluntary non-fit injuria. We did this as well. That is voluntary assumption of risk, where the person on their own assumes that risk. I gave an example about, this car racers, people who participate in car racing. They know that if there is a crash, that means there is high probability of even losing life or limb. But, they sign a contract for whoever they are, on whose behalf they are racing the car for, or whatever, or even horse riding for that matter. So they know there is the possibility of being injured, or even cricket game or any game for that matter. So they know about it, that there is a possibility of some hurt or injury or some harm that may be caused. So that comes under voluntary non-fit injuria, where the defendant needs to establish the evidence. The plaintiff was fully aware of the consequence and was determined to engage in the endangering activity, exposing him or herself to the risk involved, and damages are now claimed from the defendant. Now, in the example that I gave, the car racing example, now if, like say, God forbid, there is an accident, so the racer or the car driver will be the plaintiff in the case. He might file against the person who hires him for that purpose, for the racing, and he might claim the damages from them. So the company would say that, well, you're already aware of the risks that are involved in the game. However, but there are different contractual terms. Whenever any person signs a contract, whether it's for racing or whatever game, I mean, the contractual terms are quite they're craftily drafted in a way that would benefit even both the parties. But the problem comes when it is lopsided or when it is only one-sided. So that's a reason one has to read the agreements. But people who are in the game, they know it better, and normally they're not much hassles. But however, if there are such kind of situations, then they have the defense, the defendant. So in our example, the car, the the car company or whoever the racer is representing, they have the defense of voluntary non-fit injuria, that the person has well knowledge that there is a probability and a possibility of getting hurt or injured in case there is an accident, owing to the the speed that they drive while racing. Next is, therefore, in the law of tort, it is validly held that no person who has voluntarily waived or abandoned the right can enforce that right later. So in Latin, voluntary non-fit injuria literally means to a willing person, injury is not done. Now, this example or the case law, Blake versus Galloway, I already explained to you earlier, so I will just cross this over. Next is vicarious liability or respondent superior. That means imputed liability. Now, I gave you an example last time where there is an employer. I remember I told you about a company who has a driver, and he drives the car and meets with an accident. So the company is vicariously liable for the harm done, uh, harm caused to the people when he engaged, when he he met with an accident. So here it is, an employer is vicariously liable for the harm done by the employee in the course of his employment, or this also can be in case of principal and agent. So this is vicarious liability, which we also did. And I also gave a brief reference about English law and Somalia also, where I said that it comes under the Somali Civil Code. This particular article 171, I told you last time when we studied negligence. It's the same thing here. Now we go to inevitable accident. This is something which we have not done. Now, inevitable accident. Inevitable means something that cannot be missed, or something that has to happen. Inevitable, that is just inevitable. It means you cannot you cannot avoid that, unavoidable.